Good afternoon. This is Peter Lander, and on today it is the 21st of December 2018. This video message is to do what we call a form of service by publication in the 21st century, in the age of Twitter, in the age of emails, in the age of Dropbox, in the age of YouTube, in the age of when one can be one's own publisher, in the electronic age. When we say that service is proper, if service is given by Twitter, by Facebook, by YouTube, by email, by fax, and by paper, the very, very old-fashioned way. But today, the purpose of this message is to reconfirm and to assert that service has been given to the defendants and that service is proper, and that we intend to make the court aware that as far as time is concerned, the clock begins today on Friday, the 21st of December 2018. Now, this is the matter of civil action number 418CV811, Peter E. Lander versus Gloria LaRocque et al. This is an action that has been brought in the United States District Court for the Eastern District of Texas, particularly because we have what's called a diversity of citizenship, and it is alleged that certain crimes of a nature that affects trade and finance have been committed against a citizen of the United States of America, that being Peter Emmanuel Lander. The case names Gloria LaRocque as a defendant, or the person alleging to be Gloria LaRocque. Actually, this one is Anthony Commodore. Anthony Commodore, this is the summons for Anthony Commodore, the official summons. This was served on the parties at the onset of the filing of the lawsuit, which the lawsuit was filed on the 13th of November. We sent emails and correspondence out to all defendants, and we provided Dropbox links with the evidence and with the complaint, the copies of the complaint. So this is the summons for Anthony Commodore. This is the summons for Gloria, the person alleged to be Gloria LaRocque, and for a man named Peter Joseph, who alleges is also the attorney for Gloria LaRocque. Now, according to the rules, Anthony Commodore is the attorney of record for Gloria LaRocque and for Peter Joseph. So service on Anthony Commodore is considered service on Peter Joseph and service on Gloria LaRocque. The next parties to the suit are the defendants, the government of Dominica, for its responsibility for the judiciary, because this case has to do with matters within the judiciary, and a case brought by Anthony Commodore on behalf of Gloria LaRocque. And that case, which we have a copy of, is a deficient pleading in which the judge granted an order, and then the notice of service came in after the order was signed and entered into the docket. Now, the pleading is 17 pages, and within it is a perjury affidavit in which the applicant or the claimant or the plaintiff, in this case Gloria LaRoque, who says she comes to overturn the probated will of Carlton LaRoque, and Anthony Commodore did not provide proper service. He went in an anonymous newspaper in Dominica called The Sun and did service by publication. Today, we're doing service by video and service by publication and service through YouTube and through Twitter and through Facebook. Okay? All things being, all precedents have been taken, and all precedents are being taken. So we know for a fact that the defendants was informed at the inception of suit. We know that upon receipt of the official summons, they have been served and delivered to the defendants by email and by fax, and today by video. This is the summons for the government of Dominica. This is the summons to the Attorney General Levi Peter. This is the summons for Mr. Oswald Walsh. This is the summons for Ms. Joan Commodore. And this is the summons for Justice Bernie Stevenson. Again, Mr. Levi Peter is the Attorney General, and both Mr. Walsh, Ms. Commodore, and Bernie Stevenson are under his hierarchy. So service on the Attorney General constitutes service on those parties. But nonetheless, we had gone a step further and successfully faxed this summons out to the registrar in Dominica, to the Prime Minister's office, to the attention of the Prime Minister, and to the attention of the Attorney General. We have went a step further, and we called and spoke with the office of Anthony Commodore, in which his secretary was very rude and evasive. And we left a message for Commodore to call us to discuss the matters that we have pending before the court. We're still waiting for that call. On today, we make it abundantly clear to you, and we're going to come all the way up to the camera to make sure you can see the official nature of here with the raised seal. Okay, this is for Anthony Commodore, so you can read it. Okay, this is for Gloria LaRoque, or the person alleging to be Gloria LaRoque. We don't know that she is yet. She has to come to court and prove how she became Gloria LaRoque. Mr. Peter Joseph, a functional, a semi, well, let me not comment on people that way. But again, this is an official summons from the district court with regards to Peter Joseph. This is the, I like to begin with the summons to the government of Dominica, okay, which is this one, to the government of Dominica, okay, then to the Attorney General, Mr. Levi Peter, in his capacity as the Chief Judicial Officer for the government of Dominica. Followed, we have Mr. Oswald Walsh, and then we have Ms. Joan Commodore, and we don't want to beat up too hard on my lady Bernie Stevenson, but we have summons here for her as well, because she has placed caveats on my property out of a deficient pleading, and we are alleging that she is working in collusion with Mr. Walsh, with Mr. Commodore, with Joan Commodore, and Joan Commodore is related to Anthony Commodore, and Joan Commodore signed the caveats, the judge's orders against us and against our economic interests, and tying our hands and keeping us unable to attend to our properties on the island of Dominica and to the settlement of the estate of Carlton Larrock. So this summarizes, we have the evidence of the emails, we have the evidence of the detailed call record. That means that when I go on to my telephone bill, I have every note of every call and how long it lasts, and every fax of how long it lasts, and the number it left from and the number it went to, and whether it was successful or whether it failed. We also have the evidence of the non-failure of the delivery by emails to you. Additionally, we have provided you with a Dropbox link to all of the supporting documents that are part of the suit, and each one of you are professionals. You are officers of the court. We are lay people. I am a lay person. Okay? Mr. Levi Peter is an important political person, an important officer of the government of the state of Dominica. He has a secretary. He has the means of electronic access. There is no way he can pretend that he has not heard. And moreover, for every person whom I have spoken to and who have made and given notice on Dominica, the Office of Attorney General, the registry, the messages to Mr. Oswald Walsh, I have them all on audio recording to present to the court. So what comes after this? This says that we have served you and we have covered every basis of saving you. We didn't go in a local newspaper and put it an ad out and say, oh, it's a widely read newspaper, and expect you to see it. Even the court or the judge would never accept that as proper service to you. They know better. Okay? They know better. Now, you may think it's unprecedented that one would serve you by video over YouTube, but I'm telling you, no. This is what the norm is going to be. This is the 21st century. Judges sign orders electronically and send it to you via email. The United States District Court, and if you read the rules of civil procedure, and if you read the local rules, it says that it is assumed that if the representative or somebody have an email on file, when something is entered into the docket and they receive that email, they have been notified and they have been served. So you have been notified, you have been served, and our next move is to go before the United States District Court and to tell them that we have acknowledgement of service, that service has been proper, and that the clock began on the 21st of December 2018. So the summons says that within 21 days after you receive service, I sent you service on Wednesday. I repeated service on Thursday, which was yesterday. I followed up with phone calls that were recorded. And I also am now sending you service by YouTube, by Facebook, and by Twitter. And the official service was on the 20th, the 19th, and the 20th of December. But because I'm nicer than you, and I don't operate under the table, I'm being very open, full disclosure, okay? I am reinforcing to you that you have been served, and there's no way for you to deny that. So, to save time and money, that's it. To save time and money, that's it. So you should download the files from Dropbox, and you have 21 days to enter a response. And with that said, I look forward to number one, I look forward to speaking with you and to ironing out our differences. That is all I want. Number two, if you find yourself unwilling, unable, or choose to take a path that is uncivilized, then it will be no longer an issue of trying to resolve the matter before us and the matter in the court in Dominica in what I call a transparent way. You cannot bring a lawsuit to challenge a will and not have any proof of relationship, not have a copy of the will, claim that you don't know where the defendant is, do a false service by publication in an anonymous paper that you know the defendant will never see, except I got it. And then after I responded, all of my responses, all of my motions were never entered into the docket, and I have stamped file copies of all of those documents, and so someone has to answer for that. Someone has to answer for that. Either Mr. Walsh has to answer, either Mr. Levi Peter has to answer, and Mr. Commodore has to answer. Mr. Commodore has to answer because Mr. Commodore is a professional officer of the courts. And Mr. Commodore should never bring such a deficient pleading before the court. But the court is also at fault. The court and the judge can never accept such a deficient pleading and then enter judgments with it. That cannot stand. And in much as it affects the financial interests and the trade of a citizen of the United States of America, then we have asked the United States Federal Court to come to our aid. And we are certain that they will. So all we are saying today is that we've been very fair to you. I'm going way, way, way overboard now. Way overboard. Something you will never do. You act like you're scared to speak to me over the phone. Your secretaries act like they don't want to give me their names. I don't know what they're afraid of. Maybe they think I'm going to put a spell on them or something. Well, I can understand that because I do put spells and I do cast spells. This case, before the U.S. District Court, it is a spell. That's a spell. That's a very, very sophisticated spell. You understand? And the truth is, I am working on another one. I'm working on another case involving Mr. Walsh, involving the High Court, and involving another party who is attempting to extort from us 13 acres of land. Okay? And we're going to ask the U.S. courts. Some people in Dominica, when I speak to them, tell them what's going on, they don't understand it. Particularly, as you know, we are lay people and we haven't been to law school or anything like that. And they say, no, well, it's over there. And they don't understand the same way that I have to come over there, where you are, to answer when you bring suit on me. Is no different from me bringing suit on you over here. There are laws. There are laws amongst nations. And each country have laws to protect its own national interests and the interests of its citizens. And I don't even know what happened to my flag. I meant to bring my flag to show you. The flag of the United States of America, behind which I stand. The flag doesn't stand behind me. I stand behind the flag. Oh, there's my flag. What am I talking about? There is my flag. The flag of the United States of America that I stand behind, and which stands behind me, and which has what we call the very long arm of the law. And with the long arm of the law, we're going to reach out against those people who are transgressing against us. The only power we have, the only thing we can do is to fight with paper. We don't have guns and we do not have bullets. And even if we did, we know that we can do way more with the pen than we can with the gun. And so if you men and women who chose to be politicians and to be attorneys are not willing to fight fairly with your pens and with your words and to play by the code of ethics, the code and the rules of professional conduct, and all of those other rules, and you know, you have ethics, you have oh, I'm forgetting now, but you know, because we can't trust one another, we have different codes to determine how we work with one another, and that's why we have the rules of civil procedure, we have the statutes, and we've been evolving them over the years and amending them, and so on and so forth and so on. Now, you chose to be a lawyer, you chose to be an attorney general, you chose to be in politics. Now you're telling me that you get a little lawsuit from little old Peter Lander, and you're acting like you're scared. When I got your lawsuit, I didn't act scared. I answered you, I called you, I emailed you, and you keep ignoring me. And even now you want to pretend you're not hearing from me. Don't be a fool. God bless the United States of America, unlike anywhere else in the world. And the United States of America will forever hold supreme, regardless of what they try to do to me here. But so long as I'm here, the United States will remain protected and will have superiority over the rest of the nations of the world. And we don't make no apologies for that. But be informed that the clock has begun as of today, the 21 days for you to enter a response and to show some courtesy to the U.S. Federal Court. I sent you on the 20th of November a simple request from the court that we consent to go before a magistrate judge to try to iron out our differences. It is something that the court usually asks, and most litigants will be courteous enough to answer the court in the affirmative. Thus far you have not, just because you read my email and send me a read acknowledgement, that's not confirmation. You have to take that document, sign it, date it, scan it, and send it back to me so I can return it to the court. Right now I'm the only one who has returned to the court and said, I consent. You have not. Then I spoke to your representative yesterday at the registry, and she says, well, have there been a summons? My friend, we don't need a summons. My friend, we have a case number. And as part of the case management functions of a properly working court and legal system, the court is going to ask us to do certain things, what you call housekeeping. before ever we get to the point of a trial. So you don't lose anything by consenting. You don't admit to anything by consenting. But you stick your head in the sand and pretend that the action that Mr. Land has brought is probably a joke. Oh well, this is for all the world to see. This is not just for you to see. This is not just for your friends and for your supporters and for your detractors alike to see. This is also evidence for me to enter before the federal court. This is evidence for me to give to the federal court and for me to show them where it's posted and for me to let them know that you are a big-time politician. You pay attention to Facebook, you pay attention to YouTube. Right now you're trying to prosecute some of the opposition leaders. You finally got it in you, like I was telling you before, of how to undermine your political enemies and how to be more like Leo Austin was when he was serving as the Attorney General for Patrick Roland John. Hold on, the right Dr. Honorable Colonel Patrick Roland John. Anyway, ladies and gentlemen, be informed that the clock for service having been delivered, service having been acknowledged, and service being proper begins today. And that as a follow-up to confirm that service begins today, we will bring a motion before the court and we will enumerate the same way I'm enumerating to you on this video all of the necessary actions that we have done, all conditions precedent that we have done, and that service is proper, and then we're going to go from there. I would like to take this opportunity to wish each and every one of you a happy holiday season, and that you would keep in mind the birth of Jesus, the homelessness of he and his mother, who was an unwed woman at the time she had him, and may have been shunned by the society. I also pray that in 2019 you will be blessed with more, better health and much more wealth. And I want to thank you for the opportunity for us to speak together and for us to try to resolve the matter that have gotten us so very excited. This is all about negotiation. This is all about talking. And if people don't talk, if people don't negotiate, then you reach an impasse and you have to let someone else make a decision for you. Let us hold on to the opportunity we have now to make a decision among us and between us, and to be respectful of it and to adhere to it, and to now going forward not do this kind of corrupt things that have been done against us. If we can reach such an agreement and a settlement, it will be a great day for all of us. So I thank you, Mr. Levi Peter. I thank you, Mr. Anthony Commodore. I thank you, Mr. Oswald Walsh. I thank you, Justice Bernie Stevenson. I thank you, Ms. Joan Commodore. I thank you, the personal legend to be Gloria LaRocque. I thank you, Mr. Peter Joseph, who once was a very close friend. May the peace and the blessings of the Lord Jesus Christ, Jesus of Nazareth, be upon you, and may peace forever be with you, and may you find prosperity in this life and in the lives to come.